Good evening, guys. Today we are going to present our business law assignment, and our selected case is Baker versus Gilbert 2003. And we are presenting this case as defendant. First of all, I would like to introduce my group members. I'm Zahid Latif. My student ID is PFEC3223, and my other group members are Saklan Nawaz, Ajwad Sharif, Kamran Shehzad, and Kamran Aslam. So firstly, I'm going to give you a brief history of this case. The main parties involved in the case are Mr. Andrew Baker, who is the appellant, Ms. Karen Gilbert, the first respondent of the case, Kralk Wholesale Private Limited, the second respondent, and Nilex Industrial Products Private Limited are the third respondent of this case. Now I'm going to give you a little bit of the information, the judicial information about this case. The judgment about this case is given by two judges, Hobson and Tobias, and it's a lower court jurisdiction of district court. The lower court file number of this case is DC 9431/00, and the lower court judicial officer is Mr. Garling, the judicial court officer. And the solicitors in this case are Minter Allison is appellant for defendant, Ferrier and Associates, the first respondent for plaintiff, Otten and Kearney, the second respondent, and Kerwood and Partners, the third respondents. So what were the main issues and facts of the case? Karen Gilbert was seriously injured at Andrew Baker's premises. She landed awkwardly after jumping off an unstable footplate attached to a swimming pool ladder. Then Miss Gilbert sued Mr. Baker in the district court for damages arising out of the injuries she sustained. Garling, the judicial court officer, held that the appellant showed negligence in the inspection and maintenance of the ladder. Moreover, Andrew Baker appealed on the ground that he was wrongfully held regarding the breach of duty of care to Miss Karen Gilbert. So, what are the main relevant laws to this case in the past? First of all, the rule of common law governs the duty of an occupier to the various classes of persons who may enter the occupier's property is the form of law of negligence. Second, the New South Wales Court of Appeal held that appellant was liable and owe the duty of care. And the third one is the New South Wales Court of Appeal abandoned these artificial distinctions, assimilating occupier's liability into the tort of negligence. Now I'm going to present the defendant's arguments. Firstly, Garling, the judicial court officer, erred in finding that the footplate was unstable to a significant degree and that the instability was caused by inadequately tightened bolts. Secondly, Garling erred in finding that in discharge of his duty of care as occupier of the premises, Mr. Baker should have inspected or maintained the ladder and the footplate. Garling also took no account of the evidence of the presence of the washer between the nut and the combing, failed to apply what was said by this court in following cases: Short versus Barrett, Stannis versus Graham. So, Mr. Baker denied that he knew the instability of the footplate, and no express credibility finding was made against him. As a defendant, I presented my arguments, and on the basis of those arguments, the key analysis of the case is that Garling, the district judicial court officer, stated the footplate was unstable to a critical level. He also stated that Mr. Baker should have inspected the ladder and the footplate. Mr. Baker breached the duty of care. The judge accepted the evidence of Miss Gilbert that the footplate was wobbly. Secondly, the judge also accepted the evidence of Mr. Ferrier, which is Miss Gilbert's solicitor, who inspected the ladder and the footplate in April 1998. The judge accepted that at the time of the accident, the footplate was dangerously unstable. Judge comments on the case mentioned in the similar cases like Short versus Barrett and Stannis versus Graham. This was obvious from the facts that there was a clear gap between the footplate and the combing shown in the picture by Mr. Ferrier. The judicial officer cited similar cases for the basic test of liability, like Hawkshaw versus Shaw, Australian Safeway Stores versus Zalusna. The response of a reasonable person in the position of the appellant would have been to inspect the ladder and the footplate with care. And now the conclusion of this whole case is that the judge did not uphold the ground of the appeal by appellant. Secondly, Mr. Baker was responsible for the breach of duty of care to Miss Gilbert. Mr. Baker was also responsible for ensuring that the footplate should have been stable. The second appeal should be dismissed with cause. Thank you for watching.